Hello, everyone. Welcome. My name is Rebecca, and I'm an event planner with the Orange County Library System. Welcome to tonight's virtual event, Ask a Lawyer, presented by the Orange County Bar Association. In tonight's event, you will have the opportunity to speak with a panel of attorneys to get insight and guidance on landlord, tenant, and real estate law. Before we begin, I would like to share a couple things about Zoom. Please keep in mind that tonight, everyone's videos will be turned off besides our speakers. You will be muted unless you're asking a question, and then you may unmute yourself. If you have a question and would like to speak, please use the raise your hand feature if you click on the reactions button located at the bottom of your screen. This lets us know that you have a question. Also at the bottom of your screen, you'll see a chat feature. So you can either use the reaction button to raise your hand, or you can type in the chat that you have a question. Some people cannot use the mic, so if you want to type out your question, that's fine, but please note that I will be adding a numbered list in the chat with whose turn it's next, and I will verbally be calling out your name if it's your turn. So please respect others and wait to be called on. We just want to avoid people speaking out unless it's your turn. For those of you who are calling in, if you're calling on a phone, if you want to speak, please press the unmute button. We'll see it and we'll add you to the numbered list. So you'll just have to wait until we call on you. Without further ado, I would love to begin by introducing Luis Basagoitia, our moderator for tonight's event. Thank you so much for joining us. I'm going to go ahead and turn it over to you.
Thank you very much. So as Rebecca says, from the Orange County from the Orange County Library System, my name is Luis Basagoitia, and thank you for joining us tonight in this Ask a Lawyer event. Is sponsored by the Orange County Bar Association and Orange County Clerk of Courts. I need to give you a little background about the Orange County Bar Association. It's been around for 85 years. And it's basically, its purpose is to meet the needs of its members and reach out to the community with services and programs. The Orange County Bar Association works with the Legal Aid Society, where attorneys do pro bono work, which is work for free for people who qualify. There are other programs, the lawyer referral, the Law Week program for school children, the free citizen dispute and family law mediation program. This is a program where citizens or anybody actually who resides in Orange County can mediate or can try to reach an agreement with the other side voluntarily, and there is a mediator present who is an attorney, and it's for free. Then we have this program, Ask a Lawyer, tonight, and we're going to deal with landlord and tenant and real estate law. And I myself are going to be answering questions, as well as attorney Sid Roman, which is on the line as well. This program will be recorded and it will be shared in the Orange County Bar Association Facebook page, and please like the program in the page. Okay, so now I'm going to turn it over to Ms. Ebony Wiggins. She is she works for the Self-Help Center at the Orange County Clerk of Courts, and she'll tell you something about that.
Hi, everyone. My name is Ebony Wiggins, and I'm the Ops Coordinator for the Clerk of Courts, Orange County. And I just want to provide you guys with some information on what are some of the services that we provide in the Self-Help Center. So give me a moment. I would like to share my screen here.
Ebony, you're muted.
Hello, can you guys hear me? I'm so sorry.
Yes, you're good now.
Okay, I'm sorry. Okay, so let me go here. I'm sorry, guys. Bear with me here. Can you see my screen? Am I sharing it?
Yes.
I'm sorry. Yes, okay.
Yes.
I'm sorry about that. So the Self-Help Center assists residents who are pro se litigants who either don't have an attorney or can't afford an attorney. We serve around 25,000 customers each year at our Self-Help Center. The Self-Help Center first opened in 2015. And again, we provide legal assistance for underserved customers. We offer attorney consultations. They are virtual. We're located at the courthouse, Suite 340. Our hours of operation are Monday through Friday from 7:30 a.m. to 4 p.m. The types of cases that we provide help assistance with in the Self-Help Center are eviction, residential only, family law cases, excluding injunctions, and small claims cases. That's civil suits for less than $8,000. Again, we provide virtual attorney consultations. You can purchase your forms and you can receive completion assistance there. We provide notary and copy services. We also provide landlord tenant guidance, and our computers are available for any court-related business that you may have. Your appointments can be made online with a credit card. The fee to use your credit card is $1.50. And you can also make your appointments in person in room suite 340, but cash payments are only accepted if you're going to make your appointments in person. And attorney appointments are $1 a minute, and they're in 15-minute increments. 15 being the minimum and 1 hour being the max. And once you book your appointment, you will receive an invitation via email to attend a virtual appointment with the attorney. And if you have any questions about the Self-Help Center, you can go to myorangeclerk.com, click on the Self-Help Center tab, click on the Contact Self-Help Center. We also have a number where you can contact us directly at 407-836-6300. And again, we're located at the downtown courthouse, Suite 340. And come visit.
All right, very well. So now we're gonna open the floor for any questions you have regarding landlord and tenant law or real estate law. And Becky, the person in charge of here Zoom, she's gonna direct who is gonna ask the questions, and then we'll take it from there. Thank you.
Thank you, Louis. So first up, we have Jim, and he typed out his question in the chat. So Jim, did you want to speak, or did you want me to let's see, where is she? I can go ahead and share what he wrote. We purchased the property in Orlando in May, but the owners delayed the closing until June 30th. Moved in the night of the 30th, and on July 1st, the drain lines backed up. Called the plumber, who said that the drain line collapsed and couldn't be clear that they would have to be dug up and replaced. Sellers claimed no knowledge of this. 2 different plumbers said that there's no way this just happened. It happened over time and they had to have issues before and didn't disclose. Spoke with an attorney who said that we had a good case and would most likely win, but would never recover since we would have no recourse. Just a judgment. Cost ended up about $35,000 to replace drain lines and repair plumbing. Is it true we have no recourse?
Sid, do you want to go ahead and deal with that one?
Yes, I'm a little confused because I understand that the attorney told them that they could be represented, but they may not be a recovery. you know, the only way I can interpret that is that perhaps the evidence of maybe the homeowners knowing in advance that that was something that they could have disclosed or not may be the difficulty with the type of case. As you know, in most areas of law, you have to present evidence. And so, you know, either by factual witnesses, demonstrative evidence and such, if you can demonstrate that this was a lack of disclosure and that the owners knew previously but did not disclose, then I don't see why there wouldn't be a possible positive outcome to the new owners of the property. However, it all depends on the evidence.
I just would like to add that sellers are responsible for disclosing latent defects. Now, what does that mean? That means a defect that your inspect is not visible, basically, that an inspector cannot find. For example, a leak. If it's not raining that day, the inspector is not going to find a leak. So those are things that cannot be seen, but the seller knew about. And I think what Sid was saying is that well, at least what I'm saying, it is difficult to show that the seller knew about these things. I understand that there is the disclosure form probably that you're talking about. And that may be a way, you know, to show that they knew about it. As far as collecting, I think what the attorney was talking about is that you may win the case. You're going to have to pay an attorney's fee. So unfortunately, you may get attorney's fees back. But I think what he was talking about is you may get a judgment, but judgment is the paper that the judge signs at the end, or court order, we call it. And there is no guarantee. That's just a paper signed by the judge that you are going to make that into money or cash money. So I think that's what he was talking about. So you may spend a lot of money in attorney fees, etc., and then you get a judgment, which may include attorney's fees, but then you still have to collect on it. And so I think that's what he was talking about.
I definitely agree with you, Luis.
Thank you.
You know, taking a case through litigation and winning it is one thing where you can obtain a judgment like Luis was explaining, but then collecting on that judgment is a whole different ball of wax. I often use the analogy of if somebody told me that we were suing Tiger Woods, I can hands down tell them, oh, there's money there. We could probably recover something for sure. But when you're suing a latent person that you don't know whether they're affluent or not, or have money or not, you may end up just with a piece of paper, like Luis says, and not be able to collect it. And there are 3 popular ways to collect on judgments, although there's more, but the more popular are by garnishing wages, putting a lien against a property they may own or a business, or freezing a bank account. But as you see, each one of those depends on whether the asset does exist or not, and whether there's enough there to satisfy your judgment.
Yeah. Okay,
I hope
Becky,
that helped answer.
you want to go to the next question?
Okay, let's see. Number 2 is Kevin. So his question, oh, sorry. If you unmuted yourself, Kevin, if you wanted to speak, that's totally fine.
That's okay. You can read it, and then I'm here to answer any questions.
Okay, sure. So Kevin wrote, we need help in finding an attorney that is qualified to help us initiate a foreclosure on a property where we are holding the mortgage.
Okay. Sid?
Well, starting our foreclosure, it's usually an action that started for several reasons. One of the ones that I hear about very often is because there's been a failure of paying the homeowners association fees. And eventually an association can foreclose on the property because the owner owes those fees. Another reason that's very popular is not being able to pay the mortgage. And so both of these are
If
just
I can interrupt for a quick second.
Go ahead.
We are the mortgage holder. We're paying the homeowner's
okay.
fees. It was, we sold a house to our son and he lost a job and now he's trying to get one again and he just can't afford to pay us anymore. And he said, do what you got to do. He understands that we've invested a lot in the house and he hasn't been able to pay in over 4 months. So at this point, we figured enough time has gone. We would like to potentially initiate a foreclosure process.
I see. That definitely worthy the clarification, because I didn't know where you stood in the position as far as the mortgage is concerned. Well, then the simple answer to your question is if you find, which you should be, there's attorneys that specialize just in doing foreclosures. However, the method in which to pay them may be a combination of a retainer and perhaps some type of flat fee or hourly fee. It'll depend on the expertise of the attorney that you hire, how much you're going to be paying.
Is there a website we can go to or a phone number where we could find out attorneys that are qualified and work in this area?
If I may interrupt, I want to ask you, if it's your son, why doesn't he just sign the property over to you? I mean, that will save you a lot of money. I mean, you're holding a mortgage, but since it is within your family, it seems to me that it should be simple because he could transfer the property to you without going through any foreclosure. And, you know, there is something called a deed in lieu of foreclosure, which just basically means that he's turning over the deed to you and in exchange for you not foreclosing on him. You know, but I mean, it seems to me that you probably don't need a foreclosure here. Will you said that your son told you go ahead, whatever you have to do. So I'm assuming he will sign any documents, right?
Yeah, the caveat to this whole thing is within that time frame he had gotten married and now he's going through a divorce.
Okay.
That's what muddies the waters.
Okay. Is there equity in the house?
We don't know because we sold it to him. There probably is, but we sold it to him at a fair price at the time. We sold it to him about 1.5 years ago.
Mm-hmm. Mm-hmm.
Oh, so they don't owe the property anymore.
It's still in my son's name, but at this point he can't afford it. She moved out. He relied on her salary and his salary to pay the bills. And then he lost a job and now he's just now starting to get his feet together. So he said, Dad, you probably from a divorce point of view, you probably can go ahead and do a foreclosure then. And he may do what you suggested, Luis, but at this point, his divorce attorney said you need to start a foreclosure because that's the only way you will protect yourselves for the money you've got in the house, because we've only gotten 8 payments from them.
All right. Well, here's you could call the lawyer referral service and we'll give you that information should be emailed to you, which is the program where Sid and we both are attorneys there. And they'll refer you to a real estate attorney. Now, remember, you have gotten, and I happen to do family, and Sid probably does as well, I don't know. But, you know, you heard one opinion from the attorney, so I think you also need a real estate opinion. I understand that, you know, the divorce and that complicates things, but, you know, foreclosure is kind of like the last resort, I would say. So, but definitely, I think the attorney is onto something there because the divorce attorney, because, you know, they could consider that like a marital asset or something.
Correct.
And it depends how much equity he has, you know, I mean, if he only has like 5,000 in equity or something like that, maybe the other side doesn't care. But again, I think you need to get an opinion from a real estate lawyer, and maybe he can talk to the divorce lawyer and take it from there. You know, so you don't have to do a full foreclosure, I think.
Right. That's why we joined the call, though. If you can give us, if we can, my wife's next to me writing down things, either the phone number or the website address to contact, so we can get an attorney to talk to us. That's our
Right.
next step.
Yeah. Becky, will they be provided the contact information?
Yes, thank you for mentioning that. I'll be sending you an email after this event is over with all of that information.
Thank you. Thank you
Another
so much.
consideration may be for you to do a formal appraisal of the property and know how much the property can be sold in the market or not. So to help you make a decision of how you're going to liquidate the property. Are you going to let it go in for foreclosure, or like Luis says, could it be simple enough just to transfer it with a deed in lieu or a quitclaim deed or something like that for title purposes alone, and then adopt, if you will, or take on the mortgage yourself?
I'll just mention this before we break, or before we go. There is a custody, excuse me, a divorce order. Is the divorce in Orange County?
Yes.
Yes.
Okay, so there is a divorce order that says that your son cannot transfer any property while the divorce is going on. So that's why, you know, talk to the because you don't want your son to get in trouble.
The divorce lawyer, yeah.
Yeah, so talk to the real estate attorney, and then he needs to coordinate with the divorce lawyer, because, you know, like an agreement has to be done to get rid of this property, you know, with the consent of the other side. Yes.
Okay. Thank you. I appreciate it.
You're welcome.
Sure.
All right, our next person in line is Betty. So Betty, you can unmute, but I'll go ahead and read your comment. Am I in the propose of requesting a receivership for our HOA? Can you provide some answers with my questions? So Betty, if you want to unmute.
Can you hear me?
Yes.
Yes.
Yeah.
Okay, I'm sorry. I typed it wrong. I'm in the process of going into court and asking for a receivership for my HOA. Unfortunately, we had this young person, one person who's been on the HO board for 4 years with no treasury, no full board. So my question is, can I go into court, request for a receivership, and then have a full board to make legal decisions?
Well, I'll just say this: a receivership, you probably know this, is like somebody who's going to manage the property under court supervision. Do you know that?
Yes, sir.
Okay, so I would ask you, do you have an attorney for your association or not?
We do, the HOA does, but he is, there's a conflict of interest.
It's a conflict of interest. Okay. Well, I really don't know the answer to your question. I'm going to pass it on to Sid, but I'll just say this. They're going to email you the referral number to the lawyer referral. So, you know, after Sid, maybe he has something to say, because receiverships are kind of complex, so I'm not familiar with them. But then you certainly can make an appointment with a real estate attorney in the Orange County Bar, and they can guide you how to do this process. You need a lawyer, obviously. Your association needs a lawyer, definitely.
Yes, sir.
I agree with what Luis is saying. You will need a lawyer, and preferably a lawyer that's not connected with the association. So you're going to have to go outside and get what I would consider would be a attorney that can manage the receivership until it could be passed on to a proper board. But that's going to entail a cost. And so you'd be better served talking to an attorney that specializes in that.
And I'll just add, you know, they can refer you to an attorney at the Orange County Bar. It should be an attorney who specializes in homeownership associations. That's a very technical field, very specialized field, and there's actually people who are certified to do that. So yes, that's what you need, an HOA attorney, in my opinion.
Yes, sir. That would be helpful because at this moment, I was not successful in getting any HOA attorney, only real estate attorney who is not familiarized to this receivership.
Okay, so are you saying that you cannot get an HOA attorney? Is that what you said?
No, sir. Yes, sir. I'm not successful in that.
Okay, well, there are plenty of them, you know, because there's a lot of associations everywhere here in Florida. So,
Yes.
and they're, you know, that's all they do. Now, they do represent associations like, you know, like they only represent certain associations. So maybe because you're like an individual, maybe they don't want to take your case. But again, get a referral from the lawyer referral service in real estate and take it from there. You'll get somebody, you know, there's plenty of people who do that.
Right, right. I know. Again, it's just my frustration of not getting the HOA, but that would be great if somebody can give me that information, and I will be happy to do that phone call tomorrow.
Yeah, which like if you were to, you know, call me, you know, I will refer you probably another attorney in the Orange County Bar who would do that kind of thing.
Great, that would be helpful.
You're welcome.
And how would I contact you, Louis?
Well, they're gonna distribute the contact information from the lawyer referral after this program, and then just call the lawyer referral service, or I think you can do it online as well. And make sure you put in there that you need a HOA lawyer, so they hopefully they can track down somebody who does HOAs, you know, specializes in that. Yeah.
Yes, sir. Thank you very much. That's helpful.
Well, you're welcome.
Thank you. Our next person is Lydia. Lydia, if you want to unmute, I'll go ahead and say your comment. Can a landlord compel a tenant to clean up boxes in the garage? These boxes were there since tenant moved in 3.5 years ago. When the tenant renews her lease, can the landlord put this as provision to clear garage with these boxes?
Sid?
A little tricky situation, that is, because you're talking about objects that are inside the home. And I don't know to what extent a landlord can control what may be inside the garage or not. Obviously conditioned on the fact that whatever is there is not causing any damage to the property. So I see it a little bit unrealistic from the landlord's point of view to try to put conditions again on something that's inside the property, because really possession, which is what you would have if you're a tenant, includes every corner of the property that you're residing in or habitating. And therefore, because you have possession, you should have control of everything within the interior of that property. Is the exterior where it gets a little dicey, because the landlords have an obligation to keep the property and maintain the property. And so they have certain access to the exterior and to the structure of the property. I don't know what Louis thinks, but
all right, let me give it a let me ask you this. When did you move into this property?
Is she muted? We can't hear her.
Maybe Becky can read her the
3.5
chat.
years. 3.5 years.
3.5 years.
Yes, sir.
And when you started renting this property, this home or whatever it is, what is it? A home or an apartment or what?
It's a townhouse.
A townhouse. So when you started renting, did these things were already there?
No, I am the landlord.
Oh, you are the landlord.
I am the landlord. And
Oh,
he's the
okay.
tenant. And it's like a fire hazard.
Okay.
And
So, but let me ask you this: whose stuff is that? Who owns that stuff?
the tenant.
The tenant owns the stuff. Okay. Well, I mean, I think it depends on what, you have a lease with this person, right?
Correct.
Does the lease mentions anything about this kind of situation or not?
No, it doesn't about boxes. But
About
is
boxes.
summer is coming, and those boxes are cardboard, and they've been there for 3.5 years.
Right. Well, I mean, I don't think the tenant is violating anything. I mean, because I mean, it's their own property. I mean, like if I rent an apartment, I can have whatever I want in there, even if it's a fire hazard. I mean, if you want, you can call the fire department and maybe, but if you do that, the problem would be that they may cite you because you're the owner. So, so it's kind of iffy situation, but if the tenant, like if they were to cite you, then your lease may say something like it's actually, I don't think it could be in the lease or it could be in the statute. The statute says that the tenant has to follow the housing codes, okay? So if you call the fire inspection, the fire department, they do an inspection, that's a fire hazard, then that may be a violation of a housing code or, the fire inspection code or whatever, and then you could evict them because they're violating a housing code. And I'm pretty sure that's part of the statute. So even if it's not in your lease, it would be in the statute. So I guess that would be a way to go. Okay. Why don't you call the fire department, and see if it's a fire hazard, that's what you're saying. So, that would be a way to do it.
Yeah, the lease that I use is Florida Bar, since I am a realtor.
Oh, good. Yeah, that's a good lease.
And is that your main concern, the one that Luis is bringing up, that those boxes present a fire hazard?
Yes, because those boxes become dried up as the years go by, and it's still there. She hasn't emptied them.
They're not folded or anything. They're full of anything. Do they have any contents?
There's still contents in those boxes.
There are none. Are there?
Oh, there are contents.
There are.
So basically, she's using the boxes as storage.
Correct.
Okay.
Yeah, I mean, you can try the fire department. They may tell you we're not going to bother with that, but that's the only thing. I mean, I understand your concern. You're afraid that your property is going to catch fire. And then, you're going to have a big problem in your hand. God forbid somebody gets hurt. But I mean, again, I think it's the tenant responsibility. They don't want to get burned either, and I'm talking, fire. So, but at the very minimum, you should try to call the fire department and express your concern and see what they tell you. They may take action, they may not. But
I'll talk to her first.
Yeah, that's a good idea. Definitely.
There's always, I would always default to trying to civilly resolve the matter between you, expressing the concern that you have that it could present a fire hazard, and actually you're concerned about her. And when you put it in that context, you know, whether there's been any rift between you or not before, I think that's just would disarm anybody and realize, wow, my landlord really cares about me. So maybe I can do something halfway to meet her halfway. And so she would be satisfied as well.
Okay, I'll do that. Thank you so much.
You will.
Welcome.
Thank you. Our next person in line is Alexia. So if you want to go ahead and mute, I'm going to speak your comment. In a case, I'm being self-represented litigant. If I'm granted the civil indigent status, will I be entitled to pay the other party's attorney's fees if they win the case? And if I don't get the civil indigent status, even if I'm self-represent, will I be entitled to pay the other party's attorney's fee if they win the case?
A lot of it depends what type of case it is. What type of case is it?
Do we know what type of case it is?
Revision of the lease.
Revision of the lease? Is that what you say?
Yes.
Okay. Well, that sounds like a landlord and tenant case. You know, that's a very good question, actually. I never thought about that. Once you're declared indigent, whether my own take is yes, you could lose and you would be responsible for attorney's fees, even if you're declared indigent, because the landlord and tenant statute says that if you prevail, the judge may award fees, or the other side prevails, may award fees.
May
So,
be the operative word, though, right?
That's right, may. He doesn't have to. But you know, exactly. I mean, that's a good point. It's may. He doesn't have to. If you're indigent, maybe the judge will give you a break and not award fees. But it really, again, it's up to the judge. But let's say he does award the fees, then I don't think, you know, whether you're indigent or not, he can do it. You know, whether he, I mean, it's up to the judge to decide. And you know, the other side still needs to convince the judge to do it. If you don't have funds, if you're indigent, then the judge may not award them. But even if the judge awards the fees, you know, then is the other question we were talking earlier: how are they going to collect those fees? I mean, if you don't have anything, you know, they may just get a paper which is not worth the paper it's written on, because they cannot collect from you because you don't have any money. So it may be a empty, you know, empty gesture anyway.
But they could possibly get a judgment just on attorney's fees and cost, right?
It would have to be separate. I don't know how it would be, you know, just on that, you know.
Okay.
First, they have to win the case.
Right.
And then they can get a judgment, but you know, I see that as unlikely in a landlord tenant. Is the other side represented by a lawyer?
No, I am represent myself.
Okay, and the other side, the person you're suing or suing you, do they have a lawyer?
Because I don't have money for pay lawyer.
I understand that, but the other party, the defendant or the plaintiff, the other side, do they have a lawyer?
I am plaintiff.
Okay, does the defendant have a lawyer? Okay, Sid, you may want to try. I'm not getting through.
Yeah, basically, well, let me tell you in general terms, obviously, I don't know the judge who's presiding over your case or not, but in my experience, unless something happens in the course of your case that merits punishing the other party by assessing the fees against them, usually judges, to be fair, would tell each party, you run with your fees, you run with your fees. But again, it's really up to the judge what they do at the end. the fact that you win a case doesn't guarantee that you are going to get your attorney's fees and costs paid by the other party either.
It's up to the discretion of the judge.
Right.
We're talking about landlord and tenant. Some other fields, you know, the actual paper, the contract will say, if I win the case, I get the money, I get attorney's fees. But in landlord and tenant, it's up to the discretion of the judge.
Right.
Okay, thank you so much, because my English no good, but I understand. And thank you so much, because I need the question.
You're welcome.
You're welcome.
Thank you. Our next person in line is JD or Janae. I don't see this person still in the event. So we are going to go on to the next person, and just message me if you are here. But the next person is Janice. So you can go ahead and unmute.
Good evening. Can you hear me?
Yes.
All right. I'm a resident in a low-income senior building, and the management has summarily, based on inaccurate facts, come into each apartment, even though they were not wanted, nor had asked for an installed cable TV along with internet, and then have said we must pay the $55 for cable TV for every apartment, even though most people here don't even know how to operate the remote on the cable TV thing. We do not want it. We did not ask for it. It's based on very inaccurate facts. There are people here that cannot afford the $55 a month. It's a horrible increase in a low-income senior building for rent for every single person. We were given no choice in the matter. Either let Spectrum in, you have to let Spectrum in to install the cable TV, and you will pay for it. Whether you want it or not, whether you ask for it or not. It is not in the lease. The provision to do this to our apartments is not in the lease. In fact, they say they'll be coming around to get everyone to sign an addendum to the lease that they did that, and that we have to pay. There are people here who cannot pay it. End of story. And medical expenses are horrendous.
Yes.
So and the answer, when we say, how are we supposed to manage this, given the 5% rent increase, which will also come in the spring,
Right.
that'll be about $100 increase in 6 months. When we say, how are we supposed to manage this? Their
All right.
answer
Well,
is
let me hello.
or
Let
number
me
two,
let-
get a relative.
let me ask you a few questions. Is this a complex of apartments?
The community is a complex of apartments, not our building is, like a third of a mile from the courthouse, east of the courthouse.
Right, but
Our particular building is.
Yeah, but it is a complex. In other words, you have like a management company in there?
No, the manager is employed by the people who are the community.
Okay, so
I'm not going to give you. I can give you the name, but I would
no, don't give me the name. I don't need that. I'm just trying to determine what kind of building, what kind of apartment you have, because that is very important.
Regular senior self-sufficient apartment, just low income. That's
okay.
all.
Low income. When you say low income,
they want to improve their image. They don't want to be low income anymore.
Right. So when you say
ready is.
Okay. So when you say low income, do you mean it's subsidized by the city? or by the state or by the federal?
No, sir, no, it is not, no, it's not like Baptist Terrace or Kinneret where the ONI people come in.
Oh, okay.
There is Section 8 and all that. We are not there. This is a private, not-for-profit, church-based building. And they own any number throughout the Central Florida and the state.
Okay, the reason I was
There may be Section 8 people in here. I don't know.
I understand.
But certainly there's many elderly,
I
low income.
I understand that, and the reason I was mentioning is because, you know, I used to be a legal aid attorney, which, you know, we help people with very low funds or assets, and there is something called public housing. Now, I understand you're not in public housing, but my point is public housing has a lot of protections. I understand you're not in public housing. Yeah, this is a very bad situation. Now, one idea would be if you refuse to sign the addendum, you know, I guess they're probably going to try to evict you, you know, the way you make it sound, but you certainly have the right to refuse to sign anything. And the other thing I would say is you would benefit from a consultation with the lawyer referral service. They do have, you know, for persons with lower income, they can refer you to an attorney who helps persons with low income, low assets. And I don't know, but legal aid is also available, and you know, they may help you in this type of situation, because it is a terrible situation. I've seen it before, but yeah, I've seen it before in HOA situations. And, you know, I don't know why they do this. You know, maybe they get a kickback from Spectrum, since nobody wants this cable. But I encourage you to call the Bar Association Lawyer Referral Service. You may want to check with Legal Aid Society as well here in the Orange County, because, you know, in legal aid, we were expert. Well, we had to take any cases with public housing. And although yours is not public housing, you know, it seems to me like you were saying there are people, I'm not saying you, but you were saying there were people that couldn't afford this. So they may be evicted. And legal aid, you know, it was a priority for people who could be evicted. So you may want to try them.
They based it on a lie. They said there was federal law that required them to provide Wi-Fi and connectivity to every resident. That is not true. There is no law like that.
No, if
and
anything,
they took over I already had ACP, Affordable Connectivity Program, which gave me free internet.
Exactly, it would be free, not charge you.
They can't come in and take over my contract with Spectrum, but they say they can. They say they can do anything they want to do.
All right. Well, like I said, if you don't want to sign, nobody can force you to sign. Sid, do you want anything to add?
I would just agree.
Yeah. Pardon?
I would agree with Luis. You know, those seem to be added perks, and technology is one of those that you can choose or not choose to have, but you shouldn't be obligated to have to pay it if you don't want it.
Exactly. But there's a great deal of fear here because of elderly people. They don't have the money to move, even if they could.
Okay.
And in Orange County, Orlando, the wait list for low-income senior housing is 2 to 4 years.
All right.
So moving is not, you know.
We apologize, but we need to be moving on. I would really suggest.
Thank you very much.
Oh, yes. Call the Legal Aid Society or the Orange County Bar Association.
Legal Aid, Orange County Bar. Thank you kindly.
Yeah, you're welcome.
Thank you. Our next question comes from Mahesh. If you want to unmute yourself, feel free to do so. I'll start off with your comment. I am a commercial tenant who was evicted in 2017, LLC versus LLC without attorney. I did hire 3 attorneys, but everyone was only interested in money, not to fight the eviction. Last November, I filed 5 motions and the case was reopened. There is a continuation. Oh. That Google search and bling.com done in, I may need your help.
Okay, why doesn't he tell us what it's?
Yeah. Let's see. Mahesh, if you want to unmute. Let's see. I'm so sorry.
That's all right.
All right. I sent a request. Mahesh, if you want to unmute.
Yeah.
Let's see. Okay, there we go. Do you want to try speaking, Mahesh, so we can see if we can hear you?
Yeah, can you hear me now?
Yes,
Yes.
thank you.
Oh, beautiful. Sir, my case is like this. Did you read what I put in the chat?
Say it again.
Okay, I'm a commercial tenant who was evicted in 2017. And the eviction was LLC versus LLC. The landlord has one of the partners as attorney who's a real estate attorney. So he has like connections in the courthouse. Maybe, okay. And the next thing is, I hired like 3 attorneys because court kept asking me to hire an attorney because it is LLC versus LLC. And the attorneys were like taking only my money and like not really representing me. So finally, last November, I filed 5 motions on pro se, and they opened the case again. They have opened, they say, reopened with modification. Okay. And now I have like 5 motions. What I filed is like, first is the rent determination. The second one is lease is enforceable because lease is a 5-year lease and has no witness signatures. And this lease was signed in 2016 and I was evicted in 2017. The third point, the third motion, what I filed is security deposit because the security deposit taken from me is 17,200. And in the email, they've said we want 3 months rent as security deposit, which comes to 9,000. So they have actually misrepresented amounts to get more money from me. And then the next motion is the abuse of process, where I have paid 17,200 and they evicted me for not paying rent 13,000. So 17,200 is a security deposit. And they evicted me. I mean, I told them this is abuse of process if you go to court, because you already have the security deposit, which says, lease says you can use that for any default. But they did not agree to that. And then the last point, last motion, which is the most important, I believe, is the rent start date. The lease says the rent should start on 1st of October 2016. But lease also says time is of essence. And the property, when the landlord gave me, he promised me he'll put sign, he'll put awning, and he did not do that till January of 2017. So my concern was that the rent should start in January 17 when he put the awning and not from the October.
Okay, anything else?
That's it.
Okay, Sid, do you want to take a stab?
Well, you're no longer on the property, right?
No. I was evicted 2017.
Okay, and you're alleging that perhaps you don't owe them anything?
That's right.
And would that be the result that you're looking for, not having to pay anything?
They evicted me. They ruined my $200,000 investment.
So
It was a yogurt shop. I set up yogurt shop. So I had yogurt machines, freezers, coolers, chairs, tables. It was a franchise yogurt shop. It wasn't like mama papa operation.
all right, so you lost a lot of money in the process.
Exactly, yeah.
Is that what part of your damages is? Did you countersue them for the damages that you suffered?
No, I haven't sued them yet.
Well, maybe that would be something that I would do if I were you. If this all occurred by something that wasn't your fault, then certainly I would mount a countersuit against them for your damages. To the very least, you're no longer in the property, you no longer have the business. So it's not a matter of whether you want to continue staying there or not. You already gone. It's just a matter of trying to recover your damages.
But right now the case is open. And I am in the case. I mean, what the judge is saying is get an attorney. And the other side, the landlord side, the attorney ran away. He just quit the case. He said, I don't want to be part of this case.
They don't have a lawyer then?
No, they don't have a lawyer.
So nobody has a lawyer, huh?
Huh. Well,
that's it.
Yeah, it's not, Luis, it's not an easy answer, right? But you know, we're trained to think about the bottom line. The bottom line here is because of what happened, you suffer some damages, and that's what you're trying to recover. I would probably mount, and I'm going to use the word attack, but basically I would present my case in a way that the judge understands that you have suffered some damages and you're looking for compensation for those damages.
Right.
All right. Well, let me say this. Have they gotten a judgment against you?
I'm evicted with the judgment.
Right. How about for money? Did they get a judgment for money against you?
No.
Not yet, anyway.
No, not at all.
When did the case begin?
2017, January.
Oh, that's crazy. 3 years and it's still not over? That is something. All right. So a few things that I can tell you. You mentioned, so basically you want, with your conversation with Sid, you said you wanted to be compensated for your loss, correct?
Right.
And including the deposit, I guess. You want the deposit too.
Right.
Right. Okay. So I'll just say this. As far as this thing that you mentioned about the owning, it depends what the lease says. You know, I know you said time is on the essence, but the fact that he set up an owning in January of 17, that doesn't mean that the lease didn't begin before. I mean, it depends what the lease says. So you cannot assume that the lease is going to begin when the awning was installed. Okay, it depends on what the lease says.
Lease says the awning responsibility is owner. Landlord.
Right, but it doesn't say that the lease begins when the awning is installed. Okay, so I think you're assuming something there. It may be that the lease being.
My question is, see, when he's giving me a business property to do the business, he did not give me the full property. He only gave me part of property to do the business.
All right.
So rent starts only when he gives me 100% property. You know. Right.
Well, that's an assumption you're making. That's not. You know, as a lawyer, I cannot tell you you're right. It depends on what the lease says. It may depend on other things. You know, maybe representations that the landlord made to you orally, but you cannot assume, things that are not so.
No, it is in writing. It isn't in the lease.
Okay, so you're saying that unless the property is 100% complete, you don't have to pay anything.
That's right.
All right, well, you know, if that's what it says, you know, it's okay. I mean, it depends what the lease says. And okay, the other, I think the most important point is here that you definitely need a lawyer. This is, with all due respect, it sounds like a nightmare. The judge that's basically what he's telling you. He doesn't want to deal with this. You don't know what you're doing. Let me give you an example. You're filing motions left and right. I'm not saying that, you know, you're not intelligent, but let me tell you this. Many people assume that because the law is the English language, that they can do it themselves. And that is not true. The law is like if you were a surgeon, okay? You're not going to go and operate on somebody, you know, when you're not a doctor. You're doing the same thing here. The law is a very complex field. And just because you understand and write English, which is the tool of law, that at all doesn't mean that you know what you're doing. And I would, again, compare it to a surgeon operating in somebody who is not a surgeon, operating in somebody. So you are really getting into a nightmare here, and, you know, it's causing you a lot of headaches, I bet. And unless you get a lawyer, you may need to let this one go. That's my advice.
Yeah, but then I already paid 3 lawyers, 3,000, 9,000 I spent. But the problem is they take the case, but they don't want to represent. They don't want to appear in the court.
Well, if your lawyers are not doing the job, there's something called the Florida bar, and you can always file a complaint that your lawyers are not doing the job. But that doesn't protect you from, you know, handling your case. And my advice to you is you need to let this one go unless you get a lawyer, because it's just a nightmare, and you're not going to get anywhere. You're never going to see any money or anything, only troubles, is my opinion.
But
Yeah,
the problem is I have the money, but I should have the lawyer. No, there's no lawyer ready to take the case.
And there's also 5 motions being filed. I don't know what you said on your motions, but I don't think judges appreciate a party filing motion after motion after motion. It just really exacerbates everything. If you have an issue, you need to resolve one issue at a time and keep it simple, not complicated. And when it's time to have hearings, the problem is with 5 different motions, you're looking probably at 5 different hearings, because I don't know any judge that's going to take multiple motions and resolve them all in one hearing. So like Luis says, I think you're complicated things more, but you're not going to get around being able to pay an attorney, because your type of case is going to be a retainer case, which means you're going to have to pay money up front to an attorney to treat as a debit card to debit their hourly fee for what they do. So again, my recommendation, just like Luis, you have to find a good attorney.
I found one attorney who said, I told him I'll give you $25,000.
Okay, I'm sorry to interrupt you, but we have other questions. So respectfully, again, we already gave you our opinion, and we have experience as attorneys. And so we urge you to follow our advice, and you are going to get the information to call the Orange County Bar to talk to a landlord and tenant attorney, and you can take it from there. Thank you.
Thank you. Bye-bye.
Thank you. Okay, our next attendee, I'm going to have you unmute yourself, Roshni. If you can unmute yourself and you can say your question out loud.
Thank you. Yes, my question goes to foreclosure of a timeshare. and directly to the affidavit of diligent search by the attorney dealing with the foreclosure. And the affidavit is simply that a diligent search and inquiry to discover the current residence of the obligator has been made. And that search was then an internet Google and Bing. And now my question really is that a Google search would have revealed the obligator. The second is that even on the attorney's file, the obligator's email address and cell number was there, and the lien holder was even communicating during the relevant times with the obligator via email and mobile. So how is it possible then for that attorney in Florida to go on affidavit and state that this was diligent search was actually done for the obligator, when on their very file they have both the email address and mobile number of the obligator, and further a simple Google search would have revealed the obligator's details. And I just find that that affidavit in itself is dishonest and a travesty of justice. Now, I have already requested twice two attorneys from the Orange County Bar, and both have just simply indicated that, well, if a notice was placed in the newspaper or service was attempted at the domicilium address, that would suffice. I don't accept that at all, because a diligent search has to be made. And if a file is before you with an address, an email address, mobile number, further Google search, as they claim to have done, would have revealed information. How do I take this any further?
Sid?
Well, you can certainly file a grievance against the attorney. I don't know how far you would get with that, but this seems to me like something, again, that boils down to evidence. It's kind of hard to present evidence of somebody being negligent in doing a due diligence search. But if you have any written evidence or proof through maybe a witness that can testify that the due diligence was not done, then you can bring into question the affidavit from the attorney.
Yes. No, thank you very much. I do find that your answer. Sorry.
Let me just add a little bit to that. I agree with you. You know, you just cannot publish something in the newspaper and you're done with it, because nobody reads that, number one. So my understanding of the law is that they actually cannot find out where you are before they do a publication. And what you're telling me is that your address was obvious to everybody, or whoever the obligor is. And so I think they may have taken the easy route here, and that is definitely improper. Now, I have a few questions for you. Do you still want this timeshare?
Yes, I do.
Okay.
Yes, I do. And the only reason that there was a foreclosure was that it was a very small, just the dues, annual dues for that particular year. And it's a fully paid up in terms of the capital sum.
Right.
And I just find that these attorneys have also in their own offices gone ahead and sold that Disney timeshare at half the price that I paid for.
All right. Well, you know that you're making, you know, that's a serious allegation, but it is logical. Some timeshares, let me tell you, almost all timeshares, nobody wants them. But once in a blue moon, nobody wants timeshares unless they're Disney, really. Disney timeshares, everybody wants those.
This is a Disney timeshare.
There you go. There you go. See? So you're right. They may have done things underhanded to get a hold of this timeshare. And there is a statute. I believe it was not so long ago that was passed that allows for this, just doing a diligence, an affidavit of diligence search to make it easier to do these foreclosures, because there were so many timeshare foreclosures. I believe that the politicians changed the law to make it easier to do foreclosures. But let me ask you something. When was the judgment entered? Do you know, for the timeshare?
No, actually, I don't think it was a judgment. They just go ahead and sell. There isn't any judgment taken, but the sale was 19th of January, 2022.
Okay.
How can they possibly sell it without a judgment, Luis?
Yeah, there's got to be a judgment. There's got to be a judgment. She just probably doesn't know what,
No, sorry, they did say yes, but no, nothing was really entered against the obligator. But yes, I haven't seen. I've asked the attorneys though for a judgment.
Well,
Do they have to be an order, or?
Well, it really doesn't really matter, because, you're not an attorney, so you may be missing something there. But the bottom line is that if you want that timeshare back, I think you've been giving, in my humble opinion, I don't agree, although they may be right, but I don't agree with the attorneys who told you, to forget about this.
Exactly.
I think there is a serious problem here.
Yes.
And I also will say that Sid says about Florida bar grievance, and what that means is you file a complaint with the Florida bar against the attorneys. I will hold off on that, because that's a serious proceeding that, unless you're totally sure that they acted wrongly, you don't want to go that route. That would be my advice. But you need to, I know you already talked to two real estate attorneys from the Orange County Bar, but, I just don't buy it that, when they could have easily find out where you were, they can get a pass on this. So you need to consult with another attorney through the Orange County Bar. And if you really want this timeshare, I'm pretty sure, if research has to be done, and I would say there's something that has to be done, because, and let me ask you this. You said that the sale was a year ago, basically, right?
Yes.
Why haven't you done something earlier?
Oh, yes, that's a good question. In fact, it only came to my notice then by another party, a third party, and another entity altogether, who then found me on the Google search and informed me of the sale only in October last year. So since then, I've just been contacting and finding out.
Well,
and that entity then found me on the Google internet, which this attorney claims to have done a Google search even and was unable to. Yes. So I do have serious concerns, but I think, yes, I must take some legal advice on it.
Yes, please.
I don't see anything on the papers that they sent me which states, date of judgment or something, but I do.
Well, I wouldn't worry about that. Please get another opinion from the Orange County Bar, because I don't agree with those attorneys. I may be wrong, but definitely something looks very fishy to me here.
Yes, certainly. I think so too. Thank you very much.
I will
take it further. Thank
you.
All
right, bye-bye.
Thank you. Our next question comes from Jules. Jewel, if you want to unmute yourself, I can go ahead and read your comments. Is there a minimum amount of time you have to give a tenant if you want to not rent your property anymore? They have been there for over 10 years and they are currently on a month-to-month.
You have to give him, sorry, Sid, but that's an easy point. You have to give him 15-day notice. If they're paying you month to month, you have to give him at least 15-day notice, a proper notice that, the lease is being terminated. And that's really all you have to do. And after the 15 days are over, if they're still not out of there, then you need to file an eviction. You may be entitled to even get double rent if they're still there. But that's what I can say. Sid, if you want to add anything.
I was gonna say the same.
Yeah,
Okay, thank you so much. That's all I
You're
needed
welcome.
to know.
you're welcome.
Thank you. Okay, our next question comes from Martha. Martha, if you want to unmute yourself, I'll go ahead and read your comment. Living in rent apartment since 2004 and 3 new companies bought the property. In the meantime, the management didn't approve to change the carpet, new stove, and the paint is peel off. The worst thing, increased the monthly more than $200 per month. The managers did not want to see me and no promise that didn't do.
Okay, Sid?
It's something that happens very often, especially with loans. I haven't seen it happen too much in apartment complexes, but I guess they can change ownership. They don't need the permission of the tenants to do that, is the first thing I want to address. Any improvements or anything that's done to any apartments or residents should actually be approved by the landlord. But if you did any of those on your own, you may be running a risk that they may not approve of it. And you may have to resolve that with the landlord or the management company. They do have the right to increase the rent. I thought the increase was only a cap of 10%, but there may be some exceptions to that.
Okay, we need to understand exactly what your point is. Is it that they're not repairing things in your apartment? Is that what you're complaining about?
Good evening.
Yes.
Yes, we did move in 2004 into this apartment, and they haven't done any renovation at all. No painting, no carpet.
Okay.
The stove, the refrigerator took me 3 years to get a new one because all the seal of the refrigerator was on.
Okay. All right. Yeah. Okay. So I understand now what your problem is, and it is a very common problem when the landlord doesn't repair anything or doesn't repair certain things. Number one, to address it point, unfortunately, because I've been a tenant myself for a long time, there is no law about selling a complex. They can sell it for under you as many times as they want. That's one of the problems about renting, actually, because you don't know who new owner is gonna be. But as far as the problems that you have with your place, you need to call code enforcement, whether you're in the county or whether you're in the city, in Orange County. If you're in the city, then you need to call the city code enforcement. If you're in the county, you need to call the county code enforcement. Obviously, you ought to call the city first, because if you're not in the city, then they'll refer you to the county, or vice versa. It really doesn't matter. Because if you call the county first and you're in the city, they may refer you to the city as well. I'm not sure. But they will investigate your property for free. And they will look in if there are any problems with the property. By that, I mean any code violations, housing violations. It would be housing violations mostly. And if there are violations, they're going to cite the landlord. And believe me, they're not going to like that, because there are fines involved with that. And my experience has been that if the city or the county gets involved, excuse me, then the landlord will quickly make the repairs. Anyway, hopefully. But there is a procedure where you can withhold the rent and actually terminate the lease as well. But that is a little complex, and we cannot do it in this kind of medium right now. So if you wanna think about that and withhold the rent, or maybe even move out of the place because it is so terrible, then you can contact the Orange County Bar and talk to a landlord and tenant lawyer to guide you to do that. But in the meantime, I will call code enforcement and get that going.
Yeah, I did. I was looking by internet any lawyer regarding landlord, or I mean, as a tenant, but I haven't found, and I have been looking myself. The point is, they haven't keeping clean in the public area, and we have might, and they have been cleaning on hygiene or.
Well, sorry to interrupt you, but you're not looking in the right place, okay? You need to, you're gonna get an email with the information for our organization, and then just, you know, get in touch with them, with the organization, and they'll refer you to a lawyer, a landlord. Ask for a landlord and tenant lawyer. We have those. I am one of them. And this thing about mice, I mean, that's terrible. I mean, that's a violation right there. I mean, if it's one mice per year, it's one thing, but you know, many mice, they're gonna get.
Pool, I'm sorry to interrupt you. The pool they haven't cleaned and it's green water.
Okay,
And
so yeah, that could be a health hazard too, with mosquitoes and such. Please call code enforcement. Okay.
Code enforcement.
Yeah, code, C-O-D-E, code enforcement. And like I said, if you're in the county, contact the code enforcement in the county. If you're in the city, call code enforcement in the city. If you don't find code enforcement, which is C-O-D-E, enforcement, you can also check their building department. The code enforcement is usually part of the building department. All right?
Okay, so thank you very much. And
Thank you.
say that they will send me the information by email, right?
Yeah, we'll send you the lawyer information, but code enforcement, you have to find it yourself.
All right, I do appreciate that, and thank you very much. I have
Thank you.
Okay.
Okay, bye-bye.
All right, we have about 4 minutes, so if we can just get through this one last question, and then we'll have closing announcements afterwards. So Olga, if you want to go ahead and unmute yourself and ask your question very quickly, and we'll try to get through it in the next couple minutes. Olga? I do have a message from you. I'm going to try to see if I can get through this. The bid was on March 2022 by HOA foreclosure. The bid was done, and the new owner of the title wants to cancel the sale around now 9 to 10 months of this event. She never did a title study, and at the time she does not want to be in touch with the mortgage company, and no monthly payment done. That's all the information I have.
I don't understand the question. Maybe Sid, you understand it. I don't understand it.
No, I didn't understand it very well either.
Yeah.
Becky, if you want to read it again, maybe we can get us started.
Sure.
What is?
The bid was on March 2022 by HOA foreclosure. The bid was done. The new owner of the title wants to cancel the sale now around 9 to 10 months of this event. She never did a title study, and at this time, she didn't want to be in touch with the mortgage company, and no monthly payments done.
It seems to me, I don't know who this person is who's calling us right now, but what I seems to be getting is that somebody bought this house or whatever it is in foreclosure without doing a title search. And now they don't want to be stuck with the mortgage. And, you know, too bad. If you didn't do a title search, then you will have to deal with the mortgage
Yeah.
You may have to do like a quick title action. That's a quiet title action to clean the title. That may be a possibility. But again, I don't know who this person is, whether she's the buyer of the property or not, or what. But that's basically what I can tell you right now.
Yeah, I agree with what Luis said. It would be important to know whether it's the buyer or the seller and under what circumstances they acquired this property. When a lot of people buy property without doing a title search, unfortunately, they inherit all the issues that may come with that property. Okay.
All right, thank you so much for that. I don't have any more information, but thank you for your comments. That does conclude the end of our session. It is just about 7 o'clock and we have some last minute announcements. Louis, did you want to share?
Yes, I just wanted to thank you for participating in Ask a Lawyer program this evening. Again, if you need an attorney, you're gonna get the information by email about the lawyer referral service through the Orange County Bar. And the consultation is free for 30 minutes. And over that, there may be a charge. Thank you so much and have a good evening.
All right, and I just want to thank you all so much. Thank you for our lawyers and for the Orange County Bar Association. And Candace, thank you all so much for setting up this event and working with the Orange County Library System to host it. I do want to mention that in April, we do have another Ask a Lawyer virtual event scheduled. The topic will be family law. So that's on Wednesday, April 26th at 5:30 p.m. I put the registration link in the chat, but this will also be emailed. So just to reiterate, I will be sending an email to all the attendees tonight, just giving you guys all the information that was mentioned about the Orange County Bar Association, the Self-Help Center, the Facebook page, and in April's event. So please feel free to respond back to that email if you have any questions. I'm sorry if we didn't get to your question tonight, but please feel free to contact the Loyal Referral Service to get more information if you need it. And thank you all so much for your time. We hope to see you guys next time and have a good night.
Thank you. Good night.
Thank you. Good night, everyone.
Thank you. Good night, everyone.